Hello, everyone. It's so nice to see all of you again, and I hope that there are new persons and new faces with us today. If you are new here, or if you are already if you have already seen my webinars, for example, or maybe get acquainted with me earlier, so please write in the chat. So I'll be happy to greet you as properly as I must to do that. So welcome back. We are talking about the GDPR news because, well, it's my job to talk about that and to work with it, of course, because my name is Kateryna Dubas. I'm working in Legality Group as a privacy lawyer and head of our data protection team. And of course, I decided it would be fun to have a nice meet and greet from time to time to discuss new developments of the GDPR, maybe enforcement of the GDPR, of course, to talk about news and new finds and how we do our work and maybe the new challenges that have arisen since while we are working on our records of processing activities, something less interesting, for example. So, well, here we are. My name is Kateryna again. I'm working in Legal IT Group, head of privacy and data compliance team, and I'll be really happy to know a little bit about you too. So if you have your opener, please share it with me so I will know how to greet you properly next time and maybe say hi next time I see you in the chat too. And we will talk about news, for example. So we want to start with a long agenda. We will go to the action as well. And the tragedy of the month is legitimate interest drama, as I call it, because, of course, we have only 6 legal bases here in Europe to process personal data, and one of them, and the most intriguing one, is legitimate interest. So as far as you know, I will start with consent, and we work with legitimate interest because we use legitimate interest in all different circumstances when we have to process personal data to keep our business going, for example, or to give extra service or give extra mile to understand why we are failing in our business. And this is a way to do it properly because we do need some personal data to start our work, but still we don't want to compromise somebody's privacy when we are processing this data. And legitimate interest wasn't actually a big issue because we had this rigorous test when we decided that we have to understand what is the processing that requires legitimate interest, whether we have this legitimate interest at all, because sometimes we just can't process personal data because it's illegal and that's it. And of course, we have to assess whether it is really necessary and whether it is proportionally and necessary to achieve our goal, for example. Maybe we need some other data, or maybe we need less data to achieve our goal. And we had this test and we applied it very often. We were documenting this balancing exercise, for example, we were referring to the legitimate interest in our privacy policies. But still we had this ongoing drama with the DPA, who finds football TV for actually relying on the legitimate interest for making low profit out of it. So the thing was that this company were recording the minor football games with young players. And it was paid for establishing the cameras and recording the matches, football matches, and showing them to people. So the people will be interested in minor leagues of football and to monitor the careers of some less professional footballers, for example, or scout for talent. And in 2020, the DPA decided that, when you are recording other people without their prescribers' consent, and I remember that one football team usually consists of 11 people, and sometimes it's just really hard to collect all the consents when you have a lot of these matches per one day, for example. And they were processing the personal data without consent, but relying on their legitimate interest to, conduct the business and to show the games to other people and therefore promote the football, especially the youngster football. And, they had a hefty fine, circa 50 grams, if I'm not mistaken. And, the company couldn't make it because several months past the fine. they still weren't able to appeal the fine because they didn't have the full judgment, the full decision of the data protection authority. And they couldn't make it, they couldn't attract new sponsors for their business. Two of the earlier sponsors left them because of the legitimate drama. And well, they had to file for bankruptcy. Right now, this company is non-existent, and it was really devastating, I believe, for the employees of the company during the pandemic, because we remember that when the 2020 is the year when the pandemic started, and it was a great shock for all of us, especially for employment markets. And well, finally, this month, this drama came to its final because the Council of State in the Netherlands, namely the Court for Administrative Law, has annulled the fine imposed by the Data Protection Authority. And because, well, really a lot of people were criticizing the Dutch DPA because of the decision. Because if you tell us that the legitimate interest cannot be used to process personal data for any commercial gain, but only for not to profit from it, but only for something really distant from making profit, I believe we will be not able to conduct our business because there is great great conflict between our right to privacy and somebody's right to privacy, of course, and the other's right to, well, make business and profit out of it. And as I said earlier, not all business models can rely actually on consent, for example, or maybe on the contract, maybe on something else, because, well, there are the variety of different life circumstances when you can't actually use the instrument such as consent. Because, for example, if you have younger players of football, sometimes you will not be able to collect all the consents before the game starts, and don't do it, not collecting them, and therefore not allowing them to participate in football games, as in this case, would mean that you are actually punishing them for, well, not their lack of capacity to do all the legal things first and play the football then. And it's quite cruel when it comes to younger people who wants to be remembered, who wants to be scouted, who wants to pursue their career football jobs, and they have to be visible in some kind. And of course, this company tried to help them, and, well, now this company is non-existent, and we have a actually a good precedent when the commission even tried to facilitate this decision by asking the DPA reconsider and maybe issue another decision. But, well, the DPA persisted that the commercial interest cannot constitute a legitimate interest, and we see that it failed. So we can use at least this precedent when we are applying our own legitimate interest assessment to our own purposes of processing. And we have some argument, a really strong one, to explain why we think that our profiting from personal data can be legal, even if we are relying on legitimate interest in it. But it is not all, because we have TikTok. Yeah. And this month, well, today we are talking about July events, on the July events mostly, but I have some, backgrounds on some cases just to give you the overview. And maybe if you need the slides, for example, for your work, and or you're working on your own webinar or something like that, maybe on your own paper or article, you can use it to find all the information that you need. So we have the TikTok. And TikTok decided to, fuel a little bit its business model with advertising, and not a usual advertising, but behavioral advertising. And they decided that instead of consent, they will rely on legitimate interest. Interesting clash, isn't it? Because we have the profit in the previous case, we have the profit in this case, but somehow it feels different, isn't it? So TikTok decided to change its model, and it recorded these changes in its privacy policy and notified the users and, the publicity of its decision to apply behavioral advertising without consent, but based on the legitimate interest. And Italian DPA in this case decided that it is not okay As we remember, TikTok's DPA is Irish one. So they argued that TikTok actually violate not the GDPR itself, for example, but the e-privacy directive. And as you remember, that directive has to be transposed in the national law, and in this case, Italy has its own national law that regulates the communications, internet communications, and of course, it was amended to include the e-privacy directive provisions. And Italian DPA says that TikTok has violated or is going to violate its national law, and therefore they should stop. As we know now, Italian DPA has addressed the Irish DPA with the question what should we do next? Because remember that there is one-stop shop mechanism working in the area of fines, of course. But as we can see, new privacy policy has not come into effect on 13 July 2022 because TikTok decided to postpone the date and settle its legal disputes first. So we are looking forward to the decision to understand where is the line between the GDPR case and legitimate interest, for example, in football TV case and this recent TikTok case. Well, and here is another interesting thing. Every one of us, I believe, maybe in our household capacity, maybe for personal reasons, uses Google Workspace products because they're useful, because they're cheap, really cheap when we are not mentioning the advertising cost that we pay for it, and some other costs that we are suffering, and we are helping Google to generate from our data. But still, every one of us, I believe, at least once in our lives, use the Google Workspace product because it's efficient, and maybe because your colleagues are using it, and you can't opt out of using it because of that. So what happened? Danish DPA decided that asked the municipality that is responsible for primary schools, children, yes, to review his decision on using Google products when they're helping and assisting the primary schools with distant learning, with facilitating the remote educational process. They asked the municipality to perform the data protection impact assessment. And municipality failed to do so because the DPA wasn't really satisfied with this document. And therefore, this month, DataSolNet orders to stop the use of the product that were used to provide educational services to the children, and perform the detailed impact assessment, and of course decide what to do next and stop using Google Workspace products not later than until that deadline is. Shortly speaking, deadline is this August, and it's like 3rd of August. So we are waiting to look forward what we are doing next, because of course it's a big signal to other municipalities of Denmark and maybe some other countries as well, for example Germany, to stop using any Google products, at least when they are acting in public capacity, and at least when they are processing the personal data of children, because as we can see from the background, the first step that led to this fine was a citizen who complained to the Data Protection Authority about processing the personal data of their child, because this person saw that their child uses YouTube, and YouTube is a Google product that generates a lot of profit for Google Corporation. Therefore, even small steps can lead to big consequences, as we can see. Next thing about is Clearview. And I believe this is a company that we hear really, really often, because at least once in 2 or 3 months, we see that somebody decided to find Clearview, or maybe he or she decided to restrict its use, or maybe to review the use of this product. And this month, the Data Protection Authority in Greece decided that 20 million euros of fine should, well, preclude Clearview from working with Greece and processing the Greek personal data of Greek citizens too. Clearview is interesting because each time a European supervisory authority issues a fine or a decision or something, or starts a investigation to understand whether the Clearview is violating, in fact, GDPR. The spokesperson of Clearview says that we are not processing European data. We are American company. We are not working with citizens in your country, for example, or we are not working with law enforcement authorities in your country. We are an American company. Why you fine us? And each time we see news about a new fine, and don't see the news that Clearview in fact paid any of them, but it's quite the opposite. The Clearview decided to appeal them, and we see that this is a battle of Article 3, I believe, because we will have to understand how, in fact, we should treat Article 3, meaning the territorial competence of European data processing authorities. And we see that there is a lot of money to pay as a fine, so maybe it's really, really more profitable just to, or cost-wise, maybe to decide to appeal all of them at one bunch. We will see. We are monitoring. As of now, we have other fines from the United Kingdom. We have an Italian fine as well, and we even have a police in Sweden fined for using the Clearview services. So maybe Clearview is not really as honest about processing of, European citizens' personal data. We will see. Next, America. Because every one of us uses American products. At least Apple smartphone, Google smartphone, maybe Google Workspace products, anything. We can actually see that we have to regard the American privacy laws as well. And 20th of July, meaning a few days ago, House of Energy Commerce Committee panel voted for a comprehensive data privacy bill. It doesn't mean that it will be actually adopted, or even adopted in the redaction, the version that was voted for by this committee. But still, we have an interesting precedent because we have a few competing bills that are omnibus laws that have to impose one floor or maybe one level data protection for everyone, meaning every state in the US. And we see that it is regarded as an initiative from technology firms, because it's, of course, any lawyer that works with international law, for example, international compliance, knows that it is really more efficient to comply with only one benchmark rule than, for example, 50 competing privacy laws, because it can be quite a challenge, quite a legal puzzle to deal with all of them. And who is the most internationally working companies right now? Of course, technology firms, and who are working individually from, personal data, technology firms. So we see that there is a debate who will profit, who will get more benefits from this law. For example, the citizens of the United States, the resident of all, maybe of even all the world, because, American products are very popular. And of course, maybe it is tech firms. There is a lot of debate because we have California that has a really comprehensive data protection landscape. And some of representatives note that this bill, if made law, can restrict the protections given by the Californian law, for example, and thus make really lower the level of protection that is now used by Californians, and can be quite disappointment for them, or even limitation of their human rights. We know that privacy and data protection is not an absolute right, of course, but when you have higher benchmark of protection by law, provided by law, and then it is lower. And maybe this American Data Privacy and Protection Act will make it, well, impossible to make it higher in your own state, for example. Well, you can see that the people can be frustrated because every one of us thinks and hears a lot about privacy. We see that the interest in privacy, data protection is rising. We see that more people are becoming aware of their privacy and how companies use their data to work and to provide service and, of course, profit from it. So we have, well, concerns, especially in the light that the Roe against Roe and Wade ruling was overruled. And we see this new bill that is aimed at enhancing privacy protection across the different states. And all of us who were working with the CCPA and maybe made our companies compliant with the CCPA and who is now, well, making changes to make it compliant with the CPRA, are now confused because we don't know what to expect next. Should we proceed with the CCPA and Californian laws? Maybe we should sit and wait for the American bill becoming law, even if it can take, well, years to come. But compliance costs remain the same, and we don't see how to manage them in such a way that it won't become, well, really become a burden for our companies to make a lot of work to comply with the higher protection, for example, and then not be able to enforce it and even provide it as a service, maybe as a benefit for our marketing or maybe for our product. We are even more safe and even more privacy wise about your data because we are limited, for example, by the federal law. So we are, well, monitoring this drama. And of course, making everything in our capacity to address the new regulations. Well, let's say that. This is another part of the drama, of course, because we have a notice of proposed action, we have a comment period, and we are going to low-key prepare to the CPRA, and then we have the ADPPA, and, well, all this drama, of course, will be resolved, I believe. At least we will see what to do next. Maybe in December this year. But at least the comment period of the CPRA regs to discuss and see what is the, well, final text of the CPRA comes after this August. That's for sure. And the question that was bugging us since February, I believe, is data transfer to Russia, because a lot of talented programists, a lot of talented IT people lived in Russia and conducted business in Russia, and of course, well, had a lot of contracts with some countries of European Union, for example, that were working with Russia a lot over the years because of, well, common history ties, for example. And in July 2022, European Data Protection Board adopted a statement that said that, well, Russia is not a country that was granted the adequacy decision, so we should, well, apply the Schrems to criteria to it and maybe make our ties with, well, make us data transfers to Russia more secure. But it sounded so ambiguous and so, well, not really confident, or maybe not even well, decisive enough to understand what we should do next. Of course, we have to comply with chapter of the GDPR that deals with international transfers. But as we saw last time, we were talking about new fines. We had fines that some companies were using Russian products without safeguards, of course, as it was requested actually by the GDPR and Schrems 2 case criteria. But still, we have the statement, and I believe it's a signal that everyone should do their auditing and decide whether they need actually Russian business to work further, and maybe it is a signal that the companies have to switch to European, maybe American, maybe some other countries, processors or sub-processor or contractors in general. And of course, it is a good signal that, well, Russia is not among the adequacy decision countries, so, well, be careful with it. But personally, I'm surprised because everyone knows that, Russia did a lot to, strengthen its surveillance and strengthen the, competence of its intelligence service. And still, the European Union is concerned with data transfers to the US or China, but it's not really concerned with data transfers to Russia, or at least wasn't really concerned. And as I see it personally, it's a signal that you have to review and maybe change something in data processing. But we are still waiting for the adequacy decision, at least some maybe data processing deal between the US and European Union. And for those of us who are working with national transfers and is, for example, working with China or Chinese providers of service, and maybe you somehow missed it, that the Cyberspace Administration of China issues their own standard contractual clauses, and you can, review the initial draft because it's for public consultation. It's not the final decision yet, but still you can, for example, start switching from the European standard to the Chinese standard in case you need it. But the only caveat important is because if European Union offers you the standard contractual clauses and believes that you are using it properly and doesn't require you to file them and for review, the Chinese regulator will ask you to send them the decisions that you signed for review too. It can be changed, of course, but the way it is now, you can see from the text that you will have to file it to the CAC for review. And it is what important to know about the standard contractual clauses. Back to Google. Not surprising, Google Analytics is prohibited in France. This month's French regulator started issues a notice and questions and answers about the Google Analytics, and it's quite detailed, so you can see and find any arguments that you need to try to persuade your marketing team to switch from Google Analytics to something else. But still, the key point is that the organization who were given the formal notice have one period of 1 month to switch from Google Analytics to something else. Still even offered a list of processors that are, more expected to be compliant, let's say, because French regulator doesn't assume the liability for its recommendation. And, in fact, what the Q&A says, it is that it is impossible to work with Google Analytics in such a way that the personal data won't be transferred to the US. So in fact, if you have an ability and you have a processor of analytics in mind, so if you are not planning to work in France, Italy, Austria, or with European public authorities, you may if you have did everything else to secure this international transfer. For example, if you have not signed the contractual clauses, or maybe if you haven't used the proxy server of Google to reroute the personal data, or maybe you did something else to comply. For example, maybe you have obtained consent to send in personal data to Google when you're using Google Analytics on your website. You have to monitor the situation because, maybe one day it will be decision of the European Data Protection Board instead of single European data protection authorities. But what is interesting is that nobody is exempted from the GDPR and European Commission as well. They had a website of the Conference of the Future of Europe. Tell about irony. And Europäische Gesellschaft für Datenschutz. It is a non-commercial, if I'm not mistaken, non-commercial initiative well, find a complaint and well, wrote it to the Court of Justice of European Union that well, this website is violating the data transfer rules because it uses Amazon Web Services and of course Facebook login on its website. So if you have Facebook if you have Facebook login tool, if you are using Amazon Web Services to run your site or business, I would advise you well, to monitor this case. It will not be taken, I believe, in next few months. Maybe it will take a year, maybe a little bit more, because Court of Justice of the European Union is well card, and it can take some quite a while time to assess everything and decide what is and well, to balance the interests, to balance the circumstances, and decide what would work best for the community in a whole. Because it's not about the commission only; it's because every one of us know or uses a service that will actually use as it relying on Amazon Web Services and Facebook login. And I believe that you are not surprised to see the two names of corporations in this fine, not in this fine, but in this, well, case. The other interesting thing is that this investigation started from, let's say maybe investigation. It started from the failed data subject request. Again, data subject rights are important. Handling data access requests are important. Being transparent with your customers, with your clients, with your data subject in general is important. And you have to remember that and train the people who are responding to this request to do that properly, to address the GDPR, to include all the links, to collect and provide all the information, of course. You have to invest in training in order for the persons to be well ready to meet the challenge and to prepare the ideal, for example, to know what to do, to know what to take, to sell, to tell, to how to help, and so on and so on. And well, there are two, if I'm not mistaken, there were two data subject requests, and one of them was, well, ignored, and another one was handled in part. Not all the questions were answered, and this led to, well, to the this led the person to refer to the Europäische Gesellschaft für Datenschutz, and therefore to file in this complaint with a court that asked the Court of Justice of the European Union to issue at least a statement to understand how to treat this case. So we are monitoring it, of course. We know that the United Kingdom is no longer a member of the European Union, but it holds adequacy decision. And this month they announced, well, everyone knew it, but they finally announced that they are changing the data protection law to make it more business friendly, to get rid of some, well, some, let's say, traditional headaches. For example, quick pops that are making improper, or to provide more flexibility for consent mechanisms, and so on and so on. And we have a few key news. It's a press release about data adequacy agreement, meaning treaty, meaning like international treaty between the United Kingdom and Korea. It's important because, well, we have the period of time, the timeline, where we are not only analyzing the Council of Europe Convention 108 and GDPR, but we are relying on many. I believe that in some years we are relying on many different, for example, well, treaties from multiple parties, treaties for two parties, and so on that are regulating the data flows between the regions and maybe between the different countries at all. Well, these are always bridges between different cultures, so why not? We all have our national understanding of privacy and data protection, and all those are usually well reflecting that. So why not to see how this will work? Quite an interesting timeline. Information Commissioner issued their new strategic plan, You will see that they will focus on recruitment, they will work on predatory marketing calls, because all of us, are drowning in the spam emails and spam calls that we are receiving every day. They will work on strengthening children privacy, will work on business flexibility too, and behavioral advertising again. Hello, TikTok. And third-party cookies, because that's the things what really needs to be addressed and explained to small businesses, because not all of us can afford a data protection team that would analyze every law applicable to us and give us clear, understandable answers what to do next, for example. And the third piece of news that we have is that the government introduced Data Protection Digital Information Bill in the House of Commons. Again, we are monitoring, we are relying on the UK GDPR and DPA 28, in the recent DPA, of course. But still, we are monitoring the changes. We understand that, there is a risk of losing adequacy decision even for some time, and we have to prepare for such a scenario. And we are having, this new, this old, kindly new, battle between the European, meaning the European Union Commission, and UK's DPA, meaning how to align two regimes so the business can work in both in both regions, for example, in the United Kingdom and in the European Union as well, because we understand that the two are really closely tied, and pulling off of one of them would hurt business, a regular business, like a lot. And there are some last news for today. We are gathering information and enforcement action on a data portability right. Google faces, again, a new data portability complaint. And we know that, again, Italian DPA, not the DPA, is important, because it's not really a data protection case. It's rather a competition case, because just imagine we have a new piece of European laws called DMA and DGA, Data Governance Act, and of course DSA. And we are thinking of data brokers like a regulated business. So we have our personal data, and if companies can use it to profit from it, why can't we, data subjects, use it to profit from it? And there is a concept that is circulating around for years, having a digital wallet, for example, digital identity that you can lease to somebody, to, for example, to make the audience analysis, maybe used for some really useful advertising for us in the products that we are actually interested in, for example. And we have a lot of talented people who can make such infrastructures that allow us to have this digital wallet where you keep all our personal data that we can share with the world, and make the infrastructure of sharing it with different data controls and processors and regulate the collection and calculating of our benefit from it too. And we have the VAPL app, one of the concepts how this data intermediary can look like. And they rely on, for example, partly they rely on the Google infrastructure and then meaning the Google account to make this data wallet for a person. You can use your Google account to transfer some data to such an intermediary and not typing it again, for example, with your own hands, but simply portable it make it portable between the two controllers, the Google that you use for one service and the data wallet that you use for other service. And we understand the Google profits from advertising to us different things, so it has in fact its own data wallet on each of us, but we don't receive the remuneration out of it. We just receive free service, and it was looked on like an agreement that we can use the Google products free of charge, but instead we are sharing our personal data, so Google can sell its knowledge about us, about our desires, about our search inquiries, about our names, about everything that we use, even our Google Gmail correspondence, to offer something of value for us and making the companies that refer to Google for advertising more profitable too. And in this case, Italian competition authority says or is investigating that there is a risk that Google makes it impossible for new apps like VApple to transport this data to its own premises, for example, from Google account to the data vault, because Google doesn't want other companies get into competition with them, because of course these apps can be used for advertising too. So thus, if making right to data portability really cheap and efficient and interoperable on different systems, Google can be left without a lot of advertising, for example, because it can be easier and can be more cheap to refer to another advertiser that can lease them some data from the Apple app, for example, instead of Google. It is a pending. It is there is no there is no judgment out of yet, but it's interesting because we have this data vault, we have this digital competition. We understand that European Union moves to making this data economy fair and honest for everyone, and break this harmony, this monopoly of bigger companies, and help smaller companies achieve some effective results. And competition is really closely linked with data protection, because as we can see, we can use data to profit from it. Therefore, we will have market and we will have competition between different agents working in this market. So I personally am really interested in this case because it will explain to us how we can build these intermediaries, what can we use, what can't we use, and how the European Commission, for example, European Parliament, sees the data vaults and sees the data brokers, and see how we can legalize the data brokers that are de facto working in European economy too, but they are currently in a gray area because nobody really knows what they do. Do they sell data? Do they share data? Do they just provide some access or maybe some other service? We don't know it. We don't have the criteria to understand what they are doing and how they should be addressed in terms of the GDPR, for example, as well. So I'm going to monitor this case, and if there is any interesting case, or maybe a judgment, or maybe some other piece of reasoning worth sharing, please stay with me to learn about it, because it is my area of interest. I'm just so interested in it. And the last piece of news for today, on the 7th July, the Irish Data Protection Commission announced that it will ask the Facebook not to transfer personal data to the US. It sent its draft decision to another data protection authorities, and I believe they have 1 month to issue their own objections. So next month we are seeing it. Either it becomes ruling, we will see that the Facebook is no longer legally able to transfer data to the US, or we can see another dispute that will decide the US-EU data flows. Stay tuned. Okay. We have a question. Hello, Alexander. Well, I see. Oh, it's a lot of text. Let's discuss it maybe after the event. Maybe write us later. You see that we have a lot of contact points here. We have our email, we have our social media accounts. Could you please copy and paste this your request to one of these sources, so we can have some time to read it and address it properly. And maybe next time I will tell our listeners about the discussion and maybe help them to address a similar issue if they have one. Okay, I will be waiting for you later, so don't forget it, please. Good, thank you. Okay, so it was a lot of text from me today, and I'm sure you were a bit tired of listening to me all the time. But I hope that at least you can use the slides for your own benefit, for example, and to build your own privacy program, for example, or write a research paper, or maybe just to Google something interesting for you. So thank you again for listening to me today. Thank you again for being with us. Keep safe, of course, and please stay safe because it's important. And I hope to see you next time. So stay tuned and read and comply with the GDPR. Have a great day.